We'll start with today's presentation. Basically, our presentation will be divided into two parts. First is more of the theoretical aspects, where how the data authority structure is there and how it operates and what practical things we need to keep in mind while filing the complaints or dealing with the matter. Second aspect is certain important judgments, where we will spend more time so as to understand what kind of things comes into the picture, or what things we can face in the future and what we can do in those scenarios. And this is very there are very small act scenarios can be repeated with everyone, like 10, 15, 20 kinds of scenarios majorly, which kind of complaints comes to us. So once if we start having understanding of that 15, 20 scenarios, then majorly we can start dealing with the complaints practical way with the authority, and we can standardize the things. So first, what is the grievance redressal mechanism? So basically, I understand, just to start with or brush up the thing, what is Rera? Rera's full form is Real Estate Regulation and Development Act 2016. What is the objective of this act is to bring the transparency into the real estate transactions happening between the builders and buyers, and to set up a special adjudicating mechanism to adjudicate the disputes arising between the builders and buyers. And after this act, now civil court has no jurisdiction to entertain the disputes between the builders and buyers. So now any dispute happening between the builder and buyer on a property transaction compulsorily goes before the Rera authority only. So if there's an issue, you have to go before the Rera authority only. Now you cannot raise complaint before the civil court. So just like for listed companies, there's a SEBI to deal with. With this act, the government formed a separate dedicated authority to deal with these transactions or deal with this sector. So now real estate sector has a separate dedicated authority to supervise their transactions, to provide them guidelines, as well as to regulate and deliberate on their dispute redressal mechanism itself. So now if there's any transaction dispute between the builder and buyer, definitely we have to move before the Rera authority only. And what is the mechanism there for the grievance redressal particularly? So first, if there is any complaint you have before the builder against the builder, you can file your complaint before the Rera authority. Now Rera authority has a two courts. One, it's an adjudicating officer's court. Second is an authority's court. So depending on your grievance, which I will cover on a later part, depending on your grievance, you have to choose a particular authority and file your complaint there. That authority can hear the complaint and pass an order. Once that order comes out, you can file an appeal before the Rera Appellate Tribunal within 60 days if you are not satisfied with that order. And after tribunal's order is received, if you are not satisfied with that, you directly can move to High Court and then Supreme Court. So that is how this mechanism works. So before, first comes a Rera authority, then there comes a tribunal, then directly High Court, and then Supreme Court. Let's say once a Rera authority has passed an order, you can definitely file a review petition if there's some clerical error on a mistake apparent on the face of the order itself. You can file a review petition before the Rera authority itself within 45 days of the receipt of the order. If you want to go for an appeal, you can file an appeal before the tribunal within 60 working days from the receipt of the order, and then further you can go to the High Court. Now that 16 days specifically has been defined under the Act. So under that definition, it has been specifically mentioned that while counting these days, you are required to consider the working days only. So Sundays and the holidays are required to be deducting while calculating the days for the counting this days for the appeal. And as we discussed, now Section 79 of the Act specifically debars the jurisdiction of a civil court on such transactions. So when there is any dispute between the builder and buyer after Section 2017, and if the project is required to be registered before the Rera authority or is registrable project, dispute is compulsorily required to be raised before the Rera authority only. Who can file a complaint? So any aggrieved person can file a complaint. So means it is not necessary that you should be allotee to that project. You may be a third party. Let's say now scenarios are coming where banks are filing a complaint against the builders because they have took the project finance and has not paid off that, and now banks are exercising their rights to take over the project. Or let's say a complaint was filed, project finance was taken, and a complaint was filed in that Rera favored into the buyer's favor, but that project was that unit was already mortgaged before the bank. So banks can go to the appeal and can file an appeal against that order because their rights are getting prejudiced. Because any aggrieved person means any person whose rights are getting prejudiced by any order of the authority or any act of the builder or a buyer. So any aggrieved person can file a complaint. Majorly in those cases, it comes out then allottees because the buyer will be termed as an allottee under the act, and the term has been defined under the act as such that allottee in relation to real estate project means a person who has been sold or allotted on a leasehold basis or a freehold basis any unit in the project. So means any person who buys anything and has been allotted that particular unit in the project is terms under the definition of the allottee, whether it's a freehold, leasehold, or whether it is on a sale basis or otherwise. It comes under the definition of the allottee, and they can very well raise their complaint before the Rera authority. Now, in this scenario, a particular question was raised before a Bombay High Court in a matter of a Lavasa Corporation. There one of their project named Brookview was developed at the Lavasa city in Pune, and that project was on a long-term lease basis. So they did not take over the Rera registration, and a complaint was filed against them, wherein the promoter claimed that as a project is not for the sale, it is for a long-term lease, we do not fall under the Rera. In that case, a Bombay High Court gave a judgment that long-term lease is as good as sale, and long-term lease projects also comes under the purview of the Rera. So now, if you let's say if you buy any property at the GIFT City, in a GIFT City, everything is sold on a lease basis because government has allotted that project, that land to the on a lease basis. So even those projects are also covered under the Rera. Those projects are also required to be registered, as well as any grievances there. Then also their grievances can be raised before the Rera authority. Same way, this Gujarat Housing Board projects or AMC or ODA projects where units are allotted on a draw basis to the allottees on a lease basis. Those projects are very well falls within the purview of the Rera authority, and hence all these government authorities are required to register their project before the Rera authority and ensure all the compliances of the Rera Act, just like a private builder. So now Rera authority has a two courts under it, or there are two authorities under it. One is a adjudicating officer and second is a Rera authority. So under the act, there are certain provisions under which an allottee or an aggrieved person can claim a compensation. Let's say under section 12, if there's anything which has been committed under the brochure and that amenity or that thing has been not provided to you are entitled to claim a compensation. If you are not given a possession on a time and possession is delayed by the builder, then you can claim a compensation. So if you are claiming compensation on given that section 12, 14, 18 and 19, then you need to file your complaint before the adjudicating officer's court in a form B. Whereas there is any other scenario, let's say you don't want to claim a compensation, but you want to ask the authority to direct the promoter or a builder to rectify their mistakes, or that amenity is not provided, you want to have the directions wherein the promoter is required to build that amenity, or you want to claim an interest for the delayed period, not compensation, you want to claim an interest for the delayed period. Or if the, let's say, builder has unilaterally cancelled your allotment on a one-sided, or any society handover is not done, or society formation is not done, maintenance amounts deposits has not been transferred to the society, In all such scenarios where there is a no question of compensation, the complaint is required to be filed before the Gujarat Rera Authority. The fees also is the same, is 1,000 rupees, but the form for the complaint is Form A, whereas for adjudicating a form is Form B. Now, why it is important to choose a right authority is because if the authority has no jurisdiction to entertain the complaint, then your complaint will be outrightly rejected. So while filing a complaint, we need to see what our prayers is, and accordingly we need to select the authority or a form while uploading the complaint and have to file. Fees is same, it's 1,000 rupees, and you can file online and offline both modes. So basically, Gujarat Rera website portal, gujrera.gujarat.gov.in. On that website, there's a complaint section itself on the website itself. When you open it, you can go there, create your user ID password, and from your login, you can select which type of complaint you want to file, Form A or Form B, and you can file a complaint and make an online payment. And then you need to, in a 7 days, you have to send all your documents which you have uploaded in your complaint along with a complaint as an evidence. You require to prepare the whole set and need to invert it before the Rera authority. So this is a chart type presentation where you have to first create your user and you have to register your complaint and make a payment, and you can do that. If you don't want to go in an online mode, you just need to prepare 1,000 rupees DD in the favor of the Gujarat Real Estate Regulatory Authority's name, and along with all the documentation, and by printing that form and Form B in a physical mode, you can submit your complaint in a physical mode directly to the Rera authority if you are not comfortable filing it online. So while filing these complaints, some critical aspects which needs to be considered are: if any project which is registered under Rera or is registrable under the Rera, then only you can file a complaint before the Rera authority. So under the Rera, any real estate project means any project which is developed for the purpose of sale and which is in the town planning area or a planning area within the limits of the planning area, then it is required to be registered before the Rera authority. So against those kind of projects, you need to, if you need to read any grievance, you can file a complaint before the Rera authority. If your complaint is such that, let's say 5-10 allottees are joining together and filing this complaint, then you can file a joint complaint also. But then your issue should be relating to a common area of the project. But if your issue relates to the particularly your units only, then everyone need to file a separate complaint. You cannot club the issues of different units and file a single complaint. And your complaint should contain a statement of facts along with the list of events and the prayers you are specifically asking for. So if that is clear, then your complaint is very good to go for processing by the Rera authority. And under the new service rule which has been recently prescribed by the Gujarat authority, now once you file a complaint, the promoters are directly can under their login itself gets the notices and the copy of all the documents you uploaded, so that the time does not goes into that serving the directly copies, and the builders cannot take the recourse that we are not aware with complaint is filed, or what are the documents has been submitted, or what grievance has been raised. It is completely online in their regular login of their registered project. They can definitely see. Even they receive the email of the also from the Rera authority stating that a new complaint has been received against your project. You can check it from your dashboard. Apart from that, we on a safer side also serve a copy through registered post to the builders, so that acts as a safer side for us, that we also in addition to that submitted the copy. So once a complaint is filed, it is further examined and scrutinized. If there's any query or additional documents or evidence is required by the Rera authority, they send you an email as well as the notices. You need to comply with them. Once you comply and your complaint is okay, then Rera authorities issues notice to the builder also or the other party also to file the reply on the things. Once they file a reply, then you are given a chance to file your rejoinder, your counter arguments, and then the matter is heard on the merits, just like a court procedures, and the final order is delivered after that. So basically what your complaint should contain: a complete statement of facts of the case, what are the reliefs you are seeking, if any interim relief you are praying for, and the relevant documents as an evidence should be attached with as an enclosure. Once all these things are done and prepared, you can go to the Gujarat Rera website, select complaint filing online tab for a form A and form B, enter the details, upload the documents, make a payment of fees, and compile all a whole set and send it through a register ready to the Rera also and to the other party also, and then the Rera authority will process the your complaint. During the proceedings, you can file additional applications just like we do in the courts, or any miscellaneous applications, and that will also be decided by the Rera authority in the course of the hearings. Further, once it has been decided by the authority has a power to rectify its order. Authority also has a review jurisdiction. So once if you feel like we want to file a review against the order given, within 45 days you can go to the Rera authority and file a review with just a 500 rupees fees. Apart from that, once an order is given and that has not been complied by the other party, you can file an execution petition before the Rera authority itself, wherein copy of the order and there's a one format of the execution application. Form I is already given. In all, that form is required to be filled up, and the order is required to be attached with, and a DD in the name of a 500 rupees in the name of Gujarat Rera authority, that requires to be submitted to the authority, and the authority itself has been given a power to getting their order executed. So once the order is passed, now you have a full review. You can go for a review, or you can file for an execution, or you can go for the appeal also. And the Rera authority has similar powers to the sections 100 of CPC. Whatever power has been vested upon the civil court, that all our power has also been vested upon the Rera authority to decide any matters. So Rera authority can conduct inquiries, can call for evidences, can pass interim orders, can impose the penalties, and even Rera authority can have the site surveys or site inspection and decide the things. So as any proceedings before the Rera authority are summary proceedings. Civil code is not applicable to them, but all the powers which a civil court has, that powers to decide the matters has been granted upon the authority under the act itself. So basically this is that is first part, where the structure of the whole authority and how it operates is discussed, and what are the different options or forms, or basically a theoretical aspect, so is what are the forms are required and everything. Just a minute. Now we are moving to a second section, where what are the different sections under the act, or what are the different scenarios under which complaints are normally filed, and what is the relief that you can claim. So normally these are the scenarios under the provided under the act, as well as these are the day-to-day under these sections the complaints are raised and demands are made by the allottees. So first is unilateral cancellation of the unit. So if a builder has cancelled your unit allotted to you without any sufficient reason, there may be any reasons like payment has been delayed from us, or he might be getting some new allottee who is paying higher, or there may be terms which has been agreed upon has not been followed by the builder, or there may be like cancellation has been done, but the refund amount has not been given to you yet within 45 days or 60 days. Then you can approach to the Rera authority and ask, and make your complaint before the authority and ask for the relief. Relief can be not to restore our booking, or repayment of the amounts cancelled bookings, or let's say now there's a Supreme Court judgment which states that builder cannot charge more than 10% amount as a cancellation charges, whereas builder might have charged you 20%. So even that complaint can also be raised. Second, under section 12, loss or damage sustained by any person due to false or incorrect statement or information contained in the notice, advertisement, or prospectus, or on the basis of model apartment. So normally, if we go to buy any unit, we buy it as from based on the brochure. Now, if anything has been shown into the brochure or committed into the brochure, but that facility has not been provided with, or that construction is not done as per what has been shown, then you are very well entitled to claim the compensation, as well as the, if you don't want to continue in the project because what has been committed has not been served upon, you can even claim the refund of all the amounts you have paid along with the interest from the builder. So you have a right to decide whether you want to go for a compensation or you want to withdraw from the project. That's allottee's choice. Then 14.3, this is the prime section under which major complaints are filed. Structural and other defect in workmanship, quality or provision of services or other obligations as per agreement to sale within a period of 5 years from the date of possession. So under the Rera Act there is a provision which states that after builder gives you possession, a builder is liable for a 5 years from the date of possession for his structure defect in the structure of the building or any issues arising due to poor workmanship. So let's say leakages. If any leakages arises into or seepages arises into the building within a 1 year or a 2 year from its construction, so it means that it's a poor quality of construction. Let's say tiles or lifts are not properly working even after the proper maintenance of the same. Let's say fire NOCs are not obtained. Anything which has been should be given by a builder as a project is charged to the society, or construction there is any issues arising due to the construction defect or a proper designing of the project, then all such scenarios you can write it to the builder, and builder is required to repair the same within 30 days without charging anything. If the builder does not does that, you can file your complaint before the Rera authority along with the photographs and evidences of the things, and you can ask the Rera authority to direct the builder to rectify the mistakes. So you can claim that this leakage should be repaired, or let's say there is a leakage in the basement or in a particular unit, or there is a crack in the wall, or there's any issues there, then you can raise a complaint for that under this section. Then there's a section on section 18 where the builder delays the possession of the unit than the committed time. So let's say builder has committed you 31st December 2026 in your agreement for sale, but the project gets delayed and a possession is given after 6 months or 12 months, whatever has been committed time. Then you can claim the interest on the amounts you paid for the delayed time from the builder, because you already paid the amount as per committed time. Your amount is lying with the builder, but he did not fulfill his promise to deliver within a timeline. So you can file your complaint to claim the interest on the amounts paid before the authority. Second option you have is, if you don't want to continue in the project because the project is already delayed, then you can even claim the refund of all the amounts paid along with the interest from the date on which the amounts paid. So you can even exit from the project because the project is delayed, and you can claim the whole amount along with the interest from the project. And this is a routine scenario because no project gets committed or completed within the timeline committed. But what practically builders does is, in agreement for sale, they write a longer dates or dates which has been given to Rera for the society handover, so that in case of such disputes, they orally commit you to provide within a 2 years or 3 years. But the date mentioned in the agreement is a longer date, so that in a future, if that project gets delayed, you cannot file a complaint. So while executing that agreement, while buying the property also, we need to specifically check the possession date mentioned in the agreement, and that date should be the date which is builder is committing to us, and should not be the date which is given to the Rera for the society handover purpose. if after buying a property, there comes out any defective title on the land of the project, then also you can claim a compensation from the promoter. So practically what happens is, let's say there are many projects on which lands of that project there are civil disputes going on, but as on that there are not no stays are granted on a civil court. So builders are getting the development permission from the AMC and are doing the construction work. Now you are buying a particular property in that project, but later on it comes out that that particular civil case, if the builder loses, then your whole transaction nullifies, because as the builder does not owns that land, or the title of the builder himself is a defective, your property title also gets defective. So in those cases also you can go before the Rera authority and claim the refund or a compensation or an exit from the project, or any other terms which has been prescribed in the agreement. Let's say now many agreements are happening wherein the builders promotes the or commits the 9% assured return kind of a thing, or a particular buyback kind of a thing. If those terms are also not fulfilled, then you can go before the Rera authority to file a complaint. Then there's a particular section which states that just like a GST, we need to prepare a board and disseminate our GST number and registered office address and everything. Similar provision under the Rera Act also, wherein the builder is required to mention their Rera number and Rera website link on every advertising marketing material as well as on the website on the site of the project. So if you are going through roads, then you might be seeing the banners of the project containing the Rera number and Rera website. It is because law mandates it. So people can directly go on the Rera website, scan that QR given in the advertisement, or can go on the website and enter that registration number and can search the details of the project easily. Even here, everything is available free of cost. So if you are buying any property in a particular project and you want details of that project, complete details, you can go to the Rera website, just enter the name of the builder or enter the name of the project or a Rera number, and you can download everything. It's approved plans, it's a Raja Chitti, it's land documents, it's a 7 Bara, everything available free of cost on the Rera website. Then if the builder fails to obtain the completion certificates or a BU certificate, what we call, if a builder fails to provide the essential services, if a builder fails to form the society and hand over it, major disputes comes out that the builder is not forming the society, or society is formed but not transferring the maintenance deposits amounts. Then in such projects or in those cases also, these complaints are very well maintainable before the Rera authority. Now we don't need to go to the district register offices for the same, because what happens is builders takes 50,000 from everyone, but that amounts comes out to 3 crore, 4 crore, 5 crore, which he is utilizing interest free. So he will try to delay to hand over the same to the society. But if the society is not getting it properly, then society can raise a complaint before the Rera authority. If the builder is not executing your sale deed, or is charging wrong cancellation charges, or your agreement, like builder is required to execute registered agreement for sale before taking 10%, more than 10% amounts from you. So if your agreement for sale is for 30 lakhs or your book unit for 30 lakhs, he cannot take more than 3 lakh rupees before executing registered agreement for sale. Now notarized agreement for sales are not valid. Compulsorily registered agreement for sale have to be executed. So if builder is not executing that, in all such scenarios, you can file a complaint before the Rera authority. And all such scenarios you face if you buy a particular property. If you buy a single property, you will automatically understand these things are required to be kept in the mind. And in all such scenarios, you need to keep checking the documents and has to follow the builder to get it done. So these all were the basic scenarios under which the complaints can be raised and the issues are raised before the authority. Certain other important aspects under section 56, as we discussed earlier, now we being a chartered accountant or a company secretary or a CMA in a practice or an advocate can very well represent our clients before the Rera authority in all the disputes or any notices or everything received from the Rera authority. So it is a new area of practice which we can explore. Now section 79 specifically bars the jurisdiction of a civil court in all the scenarios I mentioned. So if you buy a property or any of your clients buy a property and faces such issues, we can very well refer them to go to the Rera only, and now civil court cannot entertain their disputes. Section 88 of the Act states that this Act is in addition to any other act. So now if you have a, let's say, you can raise a complaint under any other act also and under this act also, then this act provisions are in addition to that act, and you can very well file complaint before the Rera authority to decide that. So let's say there is a maintenance deposit issue that can raise before the DR also, but in district register cooperative that adjudication takes too much time, so a complaint can be filed before the Rera authority also. So the provisions of this act are in addition to and not in derogation to any other act. So let's say you have buy a property, the same has been the builder who took a project finance on that. Now let's say builder fails to pay the EMI and the banks issues notice under SURFACE to take over the project. In those cases, the allottees can go before the Rera authority, can make the bank and a builder a party, and can seek the stay against the bank to take over their units. Those kinds of matters are also happening before the Rera authority, and in those cases, Rera authority favors the allottees and grants the injunction in favor of the allottees. Under section 89 of the act, the act has an overriding effect, notwithstanding anything inconsistent therewith contained in any other laws. So if there is a provisions against the law, under the law, which are contradictory to the other act, then provisions of the Rera will override. There is one exception to this, IBC. Because IBC is formed by this, formed after this act, and there is a Supreme Court judgment. Now IBC overrides if there is any project promoted by any private limited company, your Rera dispute is ongoing. But if the company goes into the liquidation and IBC is admitted, then moratorium period applies, and then we have to move to the IBC and RP only. Then our complaint cannot be adjudicated by the Rera authority. And these all are the practical scenarios we are seeing day to day in the Rera office. So as we discussed, Rera authority have various powers under the civil code, equivalent to civil code, to decide the complaints on the principles of natural justice and to decide the matters. Now let's say once you are through with the Rera and the Rera has passed any order, then you can file appeal against that order within 60 days. But here also there is a provision of pre-deposit. So if there is any promoter, means a builder, against whom any order has been passed for an interest or a refund, and he needs to file an appeal, then he needs to first deposit 100% of that amount before the Rera appellate tribunal, and then only his appeal gets admitted. So this becomes beneficial because as 100% amount is required to be deposited, in genuine cases appeal will not be filed and matters will not get lingered. Similarly, if there is any penalty has been levied upon, then the promoter is required to deposit at least 30% or such other amount higher as directed by the tribunal before the Rera appellate tribunal, then only his appeal will be heard. So before the filing an appeal, if you are a promoter or a builder, then this pre-deposit is mandatory. But if you are an allottee, then there is no pre-deposit. Just by making fees of 1,000 rupees, you can file an appeal against the order of the Rera authority if the order is given against you and you want to file an appeal on it. There is one format, Form L, under which what should appeal contain is prescribed, and appeal filing time period is 60 working days from the date of receipt of the order. You can even file it later, but if there's a delay, tribunal has a power to condone the delay, so you need to file an application to delay the condone by the appellate tribunal, and on a justifiable grounds, delay is condoned and the appeals are allowed. So now these are the some important judgments which are useful in a day-to-day life, wherein in those judgments we can refer in our matters, or we can use as a precedent before the Rera authority. So basically, when the Rera Act came, there was no clarity as to what things required to be decided by the adjudicating officer and what things will be decided by the Rera authority. So in an initial period of 2018-19, 17-18, 19, many matters were going before the adjudicating officer for the delay periods interest, even that were getting decided by the adjudicating officer. So some of their matter went before the high courts and supreme courts, and then that high courts clarified that jurisdiction thing. So basically those these four are these judgments, wherein ultimately it was decided that if there is anything comes to the compensation under section 12, 14, 18 and 19. Section 12 is relating to brochure, 14 is relating to structure defect and workmanship defect, 18 is relating to delay possession, and 19 is related to duties of the allottees. If in those sections a complaint is filed for the claiming the compensation, then only the adjudicating officer has a power to decide the quantum of the compensation. But if there is any other issue or a violation of the provisions of any other provisions of the act, then complaint is required to be filed and decided by the Rera authority. So these four are that judgments wherein these issues were simultaneously came up and decided by the high courts. So it becomes important for us while filing a complaint, because once if you file a complaint before the wrong authority or adjudicating officer, they will say that after a 6 months or 8 months period, when it comes to the hearing, it will comes down that we don't have a jurisdiction to it, so we can, and your complaint is dismissed. So it will completely, you will be back to the square after a 6 months or 8 months, and will result into waste of your time. So it becomes important for us to understand this point at the initial stage itself. Then these are recent judgment which also came into the newspaper. It's a Casa Vyoma Cooperative Housing Service Society Limited versus Sri Siddhi Sumedha Space Link LLP. In particular, this recent judgment, we represented the society. In the major issue which has been decided by the Rera authority is the promoter is equally liable to make the payment of a maintenance charges to the society for their unsold units. So practically what happens is, when a builder obtains the BU and possessions are given, all the units are not sold off and members starts residing into the project. So builders starts leaving all the charges of the maintenance to the society, but they do not contribute any payment towards the society as a maintenance charges. Only members who reside there makes the payment. So ultimately those units which are unsold owned by the builder also are getting maintained from the society's amount, but he is not contributing to the society as a maintenance charges as other members are contributing. So in this judgment, the Rera authority finally decided this, stating that the builder is required to make the payment of the maintenance charges equivalent to the members for the unsold units from the date of BU till the date for which that unsold units are sold. So this is a long pending question, which was this was the first ever kind of a judgment given by the Gujarat Rera authority, directing the promoter to make the payment of maintenance charges for the unsold units. And this happens in every society practically. So this question can come before any one from us. Second, this is also a recent judgment in the matter of Eden G2R Society against the Sri Siddhi Infra Buildcon and Godrej Garden City Properties Private Limited. This is a project situated into the Godrej Garden City. So their promoter is Godrej Garden City Properties Private Limited. In a particularly this project, what has happened is there are total 8 to 10 blocks. Out of the 10 blocks, 6 or 7 blocks were completed before the Rera. So their BU was received before 1/5/2017, and 2 or 3 blocks BU were received after the Rera. So for that, 2-3 blocks were registered before the Rera authority. But builder in the 2020 formed a society, a single society, and that maintenance amounts of all the blocks combined and adjusted against each other, and no amounts has been given to the society. That dispute has been raised before the Rera authority, but Rera authority given the direction that as the all blocks are not registered under the Rera, and particular blocks which are registered under the Rera or registrable under the Rera, amounts to that blocks cannot be separately identified. We are not able to decide this complaint, and this complaint is not maintainable before us, because as pre-BU there are certain blocks whose BU is received. So this order is likely to be appealed in a short time, because in a similar matter the Rera authority has already passed an order against the same promoter. So this can be scenario where society amounts are not handed over to you, or amounts are not properly accounted for, or audited accounts are not given to you by the builder while handing over the society. Then you can raise a complaint before the Rera authority for the same and get it done. This is also one of the projects where the builder were not forming the society, because there was already a old cooperative housing society prevalent on that land. So what builder did is they take the amount in a particular non-trading corporation formed by them, and they used to maintain and manage it from that NTC. Whereas there is a specific section and circular under the Rera which states that the builder is required to form a cooperative society only, or a Section 8 company only, for a maintenance and management of the projects. But still the builder was not cooperating to do so, and amounts of like 30 crores rupees were lying with them, because project was ranging for more than 500 units. The complaint was filed before the Rera authority, and Rera authority ordered the promoter to form the society, as well as they transfer the amounts of the maintenance deposit to the society's bank account. This is one of the project located into the Godrej Garden City, wherein the society accounts were not audited, and the society got the accounts from the builder which were not audited. Society got it audited and found there are multiple discrepancies, like many bills were wrongly charged, many amounts which were part of the project expenses like STP plant, which builder is required to provide but was charged to the society account. Similarly, certain builder staff whose amounts or salaries were charged to the society. Some of the bills of the other society or other project were accounted for in this society. So all such kind of discrepancies came out into the audit. A complaint was filed before the Rera authority, and certain amounts Rera authority ordered the promoter to give back to the society. Certain demands were not allowed, and this matter is also pending before the appellate tribunal as of now from the both side. But this kind of matters are also getting adjudicated before the Rera authority. So now you don't need to go to the DR. You can file a complaint before the Rera authority for any issues in the accounts or hisabs provided by the builder. Now this is one of the matter wherein a builder had a member had not make the payment to the builder as per the agreed terms. Builder cancelled their booking and asked them to collect their checks of the refund. Builder deducted their 1,50,000 rupees from the total amount paid of 6 lakh rupees and asked them to collect the remaining amount. The complaint buyer filed a complaint before the Rera authority stating that builder is not paying me amounts and is deducting 1,50,000 rupees as a cancellation charges, which has not been agreed upon between us. Rera authority favored the builder, relying on that Supreme Court judgment in the matter of Godrej Properties, that a builder can charge maximum 10% amount as the cancellation charges. You has been charged only 6.28%, which is very well within the limit, and hence you the builder, there is no wrong on the builder side, and allottee was ordered to accept the remaining amount. This is one of the judgment which is by the Supreme Court of India, which is very useful and very much used in the court also, wherein it has been specifically stated that if there is any terms in the contract which are unfair or biased or one-sided, then those terms are not binding to the parties. Majorly what happens that when we go to buy a property, we don't read every agreement. The builder sends that, builder's advocate only prepare them, builder gets us signed it and executes it. But there are, we as we don't check it in detail, there may be terms which are one-sided which we sign. But that does not by default means that you are bound by it. You can very well raise a dispute on that too, as they were not bounding to you, but they were, you are not bound to follow them, and based on that also your complaints can be decided in your favor. This majorly this happens with everyone because the agreements are one-sided or unfair, or and hence based on the judgment of the Supreme Court, the Rera authority has given certain matters in the favor of the complainant itself. So it's not necessary that many times we may feel like, as I have already signed these papers, now I cannot go before the court and ask anything. It is not the case. If there's a terms which are one-sided or biased, you can use this judgment and raise your dispute. This is one of the matter wherein Jyoti Vinay Patakar versus Vaibhavi Vinay Patakar in versus Pacifica Lakeside. In this project, an allottee had made a payment of 37 lakh and possession was committed to be made by year 2020, that is 17 January 2020. And in that agreement, a term was mentioned that if a buyer fails to make a payment to the builder, then builder will be entitled to charge interest at the rate of 18%. But there was no rate mentioned in case the builder delivers a possession late or possession is given a late. So a complaint was filed by the allottee against the builder claiming that as the possession is already delayed, you are required to make me payment of the interest for the delayed period at the rate of equivalent rate of 18%, as you were supposed to charge me 18% as the terms of the agreement. Rera favored in the Rera favored the judgment in the favor of a complainant, as there's a provision under the Rera which states that the rate of interest payable by both the parties in both the scenarios, from builder to buyer and from buyer to builder, for the delays should be equal. So if agreement mentions that builder is required can charge 18%, then you are also required to make the payment at the equivalent rates of for the delayed possession at the rate of 18%. In one of this matter of Ratul Lahiri versus Tata Housing Development Company Limited, a complaint was filed by the allottee against the project promoted by Tata Housing Development Company, wherein there was a delay. So complaint was raised to provide the interest for the delayed period by the allottee. The stand taken by the builder's advocate was that there is no agreement for sale entered into by the builder and buyer, and hence a date of possession cannot be derived upon, and hence no interest should be paid upon. The complainant argued that though there is no agreement for sale, but there are some materials, emails, and the brochures which from perusal of which it is evident that that builder had committed me possession within 3 years. So as it is not done, I am very well entitled to claim the interest. So authority favored that even though there is no agreement for sale, but from the evidences, it is evident that the builder had committed to provide the possession within 3 years. He has failed to provide the possession, and hence complainant is very well entitled to claim the interest for the delayed period. So agreement for execution of agreement for sale is not compulsorily for claiming any relief under before the Rera authority. In one of the case of Alok Kumar versus Golden Peacock Residency, this is not the Rera's case. This is a consumer court case, but it is has been relied by the Rera authority in various judgments, and hence I have covered here it. In many cases, what happens is there is no agreement for sale entered into by the builder and buyer, and hence there are no papers wherein a possession committed date can be decided upon. So in one of such matter where there was no builder buyer agreement and entered into between the parties, so the builder claimed that as possession date is not explicitly committed or is not available on the evidences, the consumer complaint filed is not valid. So in that case, the NCDRC had ruled that you as it is not decided or the document is not on the paper, but you cannot make someone wait indefinitely for the possession of the unit, as the construction is not completed even after a period of 6 years from the date of booking. So normally in a RERA, 3 to 4 years time period is considered as a genuine construction period, and if your agreement is not executed but your booking is more than 3 to 4 years old, but your possession date committed is not committed on a paper, still you can go before the RERA authority, rely on such kind of judgments and claim interest for the delayed period, or if you want to exit from the project, you can claim refund of the all amounts paid without deducting any cancellation charges along with the interest. This is one of the matters similar. Ajay C. Vikram C. Goel versus Shivukti Developers. In this case also there was no agreement for sale. Amounts were already paid, but the builder AFS were not executed and there was no timeline prescribed. RERA, relying on that judgment, favored this matter in the favor of complainant, stating that you cannot make someone wait indefinitely. This person is waiting from last 8 years. 8 years is too much long time. They allowed the allotee to exit from the project, refund of the whole amounts paid along with the interest at the rate of 18% and legal cost of 25,000 awarded in addition to that. Then this is one of the matter in which case a sale deed was already executed, but construction itself was not done. In that case, RERA authority ordered the cancellation of sale deed, refund of the all amounts paid, along with the interest at the rate of 13.75% per annum. So even if your sale deed is executed, but your possession has not been, that construction is not completed and possession has not been given to you, and you can prove it on paper that that sale deed is done, but these things are construction itself is not done, RERA authority can direct the promoter to cancel the sale deed and refund the amounts. Recently, in one of the cases, this thing has been challenged before the appellate tribunal, and the question is whether the RERA authority has a power to order the promoter to cancel the sale deed once it is done, because through the sale deed the title is already transferred. So whether then RERA authority can pass such orders, or only civil court is the right court where the title transfer thing can be challenged upon. That question is just raised before the appellate tribunal and pending for determination in another matter. In this one of the matter decided by the Maharashtra, the cancellation charges were less than 10%. RERA favored in the builder's favor and direct the allotee to take the balance amount as it was within the limit. Then in one of this matter of Kirit carried by Mistry versus Pizzeria developers. Many amenities which has been committed into the brochures were not provided. What amenities has been provided were also not as per what has been shown in the brochure. Means image has been provided of a Audi or Mercedes and you has been delivered like a Maruti kind of a thing. So in that matter, complainants argued before the authority, proved that point, and requested the authority to direct the promoter to provide those amenities. Authority directed the builder to provide all that amenities, as well as also directed the complainant to file a complaint for the compensation in addition to this. And that matter of adjudication of the complaint is also filed, and builder, in addition to what brochure amenities has been committed, they needed to provide that amenities what has been committed, and they cannot escape that. So whatever has been committed in the brochure is or has been shown into the brochure is now compulsorily required to be provided by the builder. In all the brochures, it is standard. You may find a declaration or a disclosure at the last page on the brochure stating that this is just a representative purpose, and builder may make a change in it, but that is not binding to us. We can very well claim that thing before the Rera authority because we are buying that houses based on the representations made in the brochures only. In one of this matter also, wherein Vinod Kumar Panchal versus adjudicating officer, the authority, one of the individual allottee claimed the compensation for the common area facilities. So the adjudicating officer directed that the common area ownership lies within the society or with the society. An individual person cannot claim a compensation for the common area amenities. So complaint is required to be filed by the society as a whole to claim the common area amenities or the compensation for the common area amenities thing, because the ownership is with the society and not for a particular individual person. This is one of the project in the Gift City, WTC Noida, World Trade Center. In this particular case also, a refund was granted by the Rera authority as the possession committed was not given a time, within the given a timeline, the possession was not provided by the promoter, and the Rera authority ordered the refund of the amounts already paid along with the interest. Along with that, even the promoter was directed to make the payment of the assured returns which was committed at the rate of 11% by the promoter. So nowadays we see many schemes which commit us to provide the assured return of 9% or 8% or 10%. If that terms are very well written into the agreement for sale, then if that returns are not paid, you can raise your dispute before the Rera authority and claim the raise your dispute and get the same adjudicated. So there were certain judgments which has been more or less relied upon by the Rera authority or used by us before the Rera authority while presenting the matters. This is execution proceeding guidelines, wherein the Rera authority. Just a minute, I think. Yeah. Sorry, I think screen sharing is closed. Now it's visible.
Yes.
So
You can make it a full screen.
yeah, I'm doing that only, but it's not.
No, not yeah, this icon.
Sorry.
Move the slides.
So as we discussed now, once an authority order is passed or adjudicating officer decides your compensation and the builder does not adjudicate does not follows the same, then you need to again file an execution proceedings before the Rera authority itself. And the Rera authority has a power under the execution application to get your orders executed through collector or making a penalty per living per day penalty, or they can even one of the matters they have even started putting the builders behind the bars, but that has now not been practiced into the routine course. So that can be done by filing in a form I by just paying 500 rupees fees for it. And you can even ask for the delivery of particular property, or you can ask for attachment and sale of the builder's property. You can even ask for the arrest or detention of particular person, or you may ask for appointing receiver. In one of the matter, we have been able to get the builder's bungalow attached by the collector, and immediately the builder made whole payment of the multiple persons and got it resolved. So a mechanism is useful, but depending on a matter to matter and case to case basis, you need to decide your relief you are claiming with. So this is in nutshell. I have tried to cover the things on a grievance aspects, and we are open to question answer round if anyone has any questions or practical things if anyone wants to ask.
So there are few questions in the chat box.
Yes.
So one clarity with respect to the terminology which is used in Rera Act, that is structural and other defect in workship quality means. And is there any list as per cases in your practice?
So particularly what has happened is under the Gujarat RERA rules, there is a no definition as to what is structural defect or what is poor workmanship. But majorly, leakages are covered in leakage in matter of leakages, the seepages in the basements or any place of the project or units. RERA grants it in a favor, and it is considered as a due to poor workmanship, as well as routine anything which is not due to routine maintenance. Like if builder has already handed over society to the society to the chairman secretary, now you are not renewing your lift license, or you are not renewing your lift AMC contract, and due to that if any issue is arising, then that may not get adjudicated. But otherwise many issues like leakages are given, then any repairing works are given, then let's say in a common there's a compound wall is not properly structured, or the parking tiles are not properly provided or broken within 3 to 6 months of the installation. Sometimes CCTV or certain facilities are not provided. So, and practically while advising client, what we advise is you claim everything. Let RERA decide whether it is covered or not. But you need to make out a case that why it is happening. Because if builder has provided it with a good quality, this issue would not have arose. Then it is 50-50. But if quality itself is in a question, then you definitely can raise it. Because in one of in cases of we are representing in a Baroda, in elevation within a 1.5 year, the whole elevation color has gone. The building was of a particular color, now it completely appears of a different color. Seepages are across the basements and the lifts and everywhere, and water accumulates while if there comes out even in a small rain, a water accumulates along the whole project. So all such kinds of our valuable can be raised upon, and you raise your point, let RERA decide, while we should back out that this is covered or not, or we should primarily decide. It's up to the RERA authority. It might happen that it gets adjudicated, but major issues are considered as a, because if it is due to the builder's fault, and also a timeline also requires to be seen, like if a building is just a 1 year or 2 year or 3 year old, but if a building is 4.5 year or a 5 year old, then how the things, particularly the timeline also is required to be seen upon.
Okay. So there's another question. Does the scheme brochures can be the evidence for the facilities, amenities, this will be provided by the builder. Can we use this brochures as a proof?
Yes, that is the prime evidence, because when we go to buy any property, we see the brochure. Based on that brochure only, we buy a property. Now, what has been committed or has been shown in the brochure is not delivered at the builder site, then definitely we can put up comparative photographs of the location as an evidence, and seek the compensation or claim the interest or claim the uh, direction to the builder to get the things done.
Okay. So, someone has raised hands from the participant. They can unmute themselves and ask their questions if they want. Please raise your hands to ask the questions directly. And meanwhile, you can post if any other questions are there in the chat box. We can take those questions. Okay. So, I think we can conclude the session or ask if anyone have any questions, then please ask.
Question,
Or write in the chat box.
this Kashyap Gandhi has raised the hand.
Someone is saying,
Kashyap ji, hello.
he is unable to unmute himself. Anyways, we can post the questions in the chat box, or you can connect with the speak. Kashyap ji, are you able to speak? I think his voice is not audible. You can write your question in the chat box. And meanwhile, I request all the participants to please share your feedback, valuable feedback in the chat box for all the efforts which has been put by the organizers and the speaker for conducting today's session. Meanwhile, we have one question. If the builder had collected GST at the rate 5% and paid only 1%, can the RERA help?
I think that will definitely go before the GST anti-profiteering authority, because as there's a specific mechanism to that, RERA will not be able to access the books of the builder, but definitely RERA GST department will be able to check the returns and everything. And I have come across various such orders of the GST anti-profiteering authority, wherein by raising their complaints, they have checked the books of the, even they have sent the notices to the builder and verified everything, and has asked them to pass a particular amount of GST credits to particular members. And majorly this has happened in the cases of the bungalows, wherein schemes were already in the process, where this 1% 5% rule came into 2019-20. So before that, builders used to charge 18% and 12%. So they were at that time, if do the proper working, then their amounts were significant for the GST credits, but they did not pass it. So one Vardhaman Cooperative Society's case of that for the GST thing is very much known in the fraternity. Apart from that, certain good builders I cannot name here, but have also got that notices based on the complaints of the members raised before the GST authority, as well as you can simply write it to PMO, CMO grievance portals, and from that also they direct and get the notices. So that is also one of the way of doing it.
Okay. That's all for today. Thank you so much, Lokesh ji, and everyone on the panel, Pankaj ji, for connecting us and organizing this entire, making it possible, and Ashish Chekwani ji and Kartikeya ji, who has joined us in the beginning of the session, and all the participants. Thank you all for joining. And now I request Pankaj ji to please give a formal vote of thanks to all our participants. Over to you, Pankaj ji, and our speaker.
Respected Lokesh Shah, uh, organizers Dipti ji and AGFTC, GSTB, ITBA, office bearers, and all the members who joined this webinar, I heartily thank you, all of you. And I also thank you speaker जिन्होंने रेरा के बारे में एकदम थरली से बहुत अच्छे से हमको मार्गदर्शन दिया, गाइड दिया। और ये हमारी डे टू डे प्रैक्टिस हमारी जीएसटी इनकम टैक्स की है, पर ये चीज़ आपने इतनी अच्छे से समझाई कि कहीं न कहीं हमको ये उपयोगी रहेगी। और खास दीप्ति जी जो काम कर रही है सभी पार्टिसिपेंट के लिए, ये काबिल तारीफ है। मैं सबका आभार व्यक्त करता हूँ और आगे भी सबका सपोर्ट मिलता रहे और अच्छे से हम वेबिनार करते रहे। थैंक यू। We conclude this session. Thank you all.
Thank you all for having me.
बहुत बहुत
It's my time.
धन्यवाद.
Thank you.
Thank you so much everyone. And thank you everyone for joining. Stay tuned with GyaanStation and all the organizations which are associated with us, so that you can remain updated with all the upcoming webinars, series and programs which we are coming up. Twice a week, we will be conducting webinars. Tuesday and Friday, timing is same, 5 to 6:30. Again, we will come up with some very important topic which is going to be very helpful for you. So please stay in touch with all of us. Thank you so much. Here we end our today's session.